Hello, welcome to CMA update. Today we are going to see paper number 12, audit, study note number 7, latest changes. The first thing that has been changed, that is, what are the manner and procedure of selection and appointment of auditors. Rule 3. First one, point number 1. In case of a company that is required to constitute an audit committee under section 177, the committee, and in cases where a committee is not required to be constituted, the board shall take into consideration the qualification and experience of the individual or the firm proposed to be considered for appointment as auditor, and whether qualification and experience are commensurate with the size and requirement of the company. If there is a need for audit committee by a company, then the audit company will recommend an auditor. That auditor, if agreed by the board of directors, then he will be the auditor of the company. If there is not need for or not required for an audit committee to be constituted, then the qualification and experience of an individual or the firm proposed to be considered for appointment as auditor will be considered with the size and requirement of the company. The size and requirement, if the company is big in nature or small in nature, according to the size, the experience and the qualification of the audit experience may be less or more according to the size, but qualification should be a chartered accountant or a cost accountant for a respective audit. Point number 2. Provided that while considering the appointment, the audit committee or the board, as the case may be, shall have regard to any order or pending proceedings related to professional matters of the conduct against the proposed auditor before the Institute of Chartered Accountants of India or any competent authority or any court. Let's underline this. The pending proceedings of the auditor need to be checked before appointment, and the professional matters conduct, the behavior of him also need to be checked before the Institute of Chartered Accountants of India or any other competent authority or any court. That's what it tells in this paragraph. Point. The audit committee or the board, as the case may be, may call for such other information from the proposed auditor as it may deemed fit. The audit committee or the board of directors may ask any information related to his profession, and the auditor, proposed auditor, need to give it. That's what tells in this paragraph. Subject to the provisions of sub-rule 1, where a company is required to constitute, the audit committee shall recommend the name of an individual or a firm as auditor to the board for consideration, and in other cases the board shall consider and recommend an individual or a firm as auditor to the members in the annual general meeting for appointment. The audit committee need to recommend the name of the auditor to the board of directors, and the same will be go to the members of in the annual general meeting, and the appointment will be happen. This is the procedure and the process. Fourth one, if the board agrees with the recommendation of the audit committee, it shall further recommend the appointment of an individual or a firm as auditor to the members in the annual general meeting. If the board agrees, then the recommendation of the auditor will be agreed, and the same person will be appointed as the auditor by the consent of the annual general meeting by the members. If not, that's what we are going to see in the other thing. If the board disagrees with the recommendation of the audit committee, it shall refer back the recommendation to the committee for reconsideration, citing reason for such disagreement. Board of directors shall give the proper reasons for why they disagree or not accepting the auditor recommended by the audit committee. If the audit committee, after considering the reasons given by the board, decides not to reconsider its original recommendation, the board shall record reasons for its disagreement with the committee and send its own recommendation for consideration of the members in the annual general meeting. If they are not agreeing, the audit committee is not agreeing with the board, then audit committee may not have the power and the board will go forward to the members, and if the acceptance is given, then in the annual general meeting he will be appointed as the auditor. And if the board agrees with the recommendation of the audit committee, it shall place the matter for consideration by members in the annual general meeting. As I explained before. 7. The auditor appointed in the annual general meeting shall hold office from the conclusion of that meeting till the conclusion of the next 6th annual general meeting, with the meeting wherein such appointment has been made being counted as the first meeting. The day on which he is appointed is the first meeting, until the 6th annual general meeting he will hold the office. What are the conditions for appointment and notice to the registrar? Number 1. The auditor appointed Rule 3 shall submit a certificate that the Rule 3 refers to this Rule 3, selection and appointment of auditors. A. The individual or the firm, as the case may be, is eligible for appointment and is not disqualified for appointment under the Act, the Chartered Accountants Act 1949, and the rules or regulation made thereunder. Here, the not disqualified by the Chartered Accountancy Act need to be confirmed before the appointment, or any other rules or regulation made thereunder. B. The proposed appointment is as per the term provided under the Act. You have to check whether it is as per the term under the Act. And C. The proposed appointment is within the limits laid down by or under the authority of the Act. We need to check that whether it is under the limits of the Act or the authority. D. The list of proceedings against the auditor or audit firm or any partner of the audit firm pending with respect to the professional matters of conduct as disclosed in the certificate is true and correct. You have to check whether the pending proceedings and the other conduct related matters need to be disclosed in the certificate. 2. The notice to registrar about appointment of auditor under 4th proviso to subsection 1 of section 139 shall be in form ADT1. ADT1 is the form number for which the appointment of auditor takes place. If you like this video, give a thumbs up and subscribe to this channel and share this with your friends so that they will also benefit out of it. And thank you for watching.